Well, hi all. Thanks for coming. I'm Chris Bloomfield. I'm an associate at the Eversheds Sutherland, DC office. I'm in the cybersecurity and data privacy group. A lot of what I do there is handling incident response, much of which becomes international. I work closely with Rachel, who's a partner. I'll let you introduce yourself.
Hi, Rachel Reed. I'm a partner based out of Atlanta with Eversheds Sutherland. I actually recently rejoined the firm after 17-ish years in-house, most of which as the Chief Privacy Officer of Voya Financial. So a lot of experience doing incidents in-house. I'm also part of the firm's data privacy and cybersecurity practice, and I lead our artificial intelligence practice in the US.
And hi everyone, my name is Ming. I'm a legal counsel at Google Cloud. I, for the past few years, have been counseling Mandiant after the acquisition. And then in particular, I am the person who oversees all of our litigation of regulatory matters that come in from our customers through third parties.
The topic of today's discussion is going to be the issue of privilege while doing incident response, especially as it pertains to in-house counsel and when you're doing international incidents. The privilege issues with incident response tend to differ a little bit than normal, right? It's not as if you're getting sued and you're gonna go hire a lawyer to handle it. A lot of what we're doing here is sort of setting the stage before litigation happens. So that's sort of what we're trying to do is basically set ourselves up to be on the best footing possible in case we end up litigation down the line. The international aspects of this we'll get into later, but the sort of parameters around when privilege applies differ in different jurisdictions. So if you're handling an incident that might span over 3 or 4 different countries, you're gonna have to be thoughtful about how and when privilege will apply and then how to best address that. And we'll be giving you guys sort of some of our war stories and then best practices for how to handle these incidents. Some of the myths we come across a lot tend to fall into the category of, well, my lawyer's in the thread. I told a lawyer about it. That is often misconstrued as something that would automatically provide privilege. Or saying that, well, a lawyer drew this, or a lawyer's on the email. Even if I forwarded it to somebody else, a lawyer saw it first. And so we'll go into sort of the components of attorney-client privilege, work product doctrine, and confidentiality, how those sort of interlink, and the pitfalls that come along with sort of some of the misconceptions about when privilege applies.
Can we do a quick show of hands? How many in the audience are lawyers? Okay, how many of you work regularly with lawyers? Yeah, don't be embarrassed, you're in good company. Okay, perfect. Thank you.
Can I ask how many of us have been sued?
Okay.
Yeah, so I guess to set the stage for those who maybe haven't had a privilege training recently, attorney-client privilege very basically has 3 elements, right? It has to be a confidential communication, so it's meant to be kept confidential. If you say it outside in the presence of other parties, it's no longer confidential, right? It has to be between the attorney and their client, not between the attorney and a third party who has similar interests, or someone who heard the advice from an attorney, but literally between the attorney and their client. And it has to be made for the purpose of obtaining the legal advice. So you chatting with the attorney, often if they're in-house counsel, right, may not always be about seeking legal advice. It might just be about something entirely business related, right? For attorney-client privilege to apply, it has to have those 3 elements. So that's your takeaway from Legal 101. Yeah.
So the reason that privilege is especially pertinent when we're handling incidents is because a lot of the early communications, especially surrounding an incident, if those are to be turned over during litigation or a regulatory investigation, can be very damaging. So what we tend to see sometimes is, right, there's an alert, the incident response process goes into effect, but lawyers aren't necessarily copied on it, right? The IT guys, the InfoSec teams start chatting among themselves and start creating a written record where they might be discussing things that, in their sort of mission to figure out what went wrong and how to fix it, they are creating a record that sometimes can be very unfavorable. So in the event that, right, we have to turn those over, if they're not privileged, we're gonna have to turn those over to an opposing party. And so when they see things like, okay, here's a whole, right, email thread where, we discussed, oh yeah, we knew about this, but we didn't fix it, we didn't have the budget to do it. Or, oh yeah, I meant to get around to that. Or, speculative, right, I think it might have been this. Later on, it turns out that isn't true, and then we have to kind of backtrack and explain, well, this is how the story has changed. Those things really stand out. And Ming, I thought you had mentioned earlier, made a good point about how plaintiffs are really honing in on how to search through, right, inboxes and stuff like that.
Yeah, so obviously Google has had a number of lawsuits against us in the past as well. And there have been a lot of plaintiffs these days who are getting more, technical in how to search for ways that in-house counsel are perhaps moving out of that legal box into a more business box. So even searching for terms like, let's take this offline, or let's talk about it live. If they find those terms, and then they ask for the associated emails surrounding that to try and sort of put together a fact pattern that you are actually talking about business items and you chose to take it offline merely to be able to preserve the privilege of that conversation or try and claim the privilege over that conversation, where in reality, had that continued, perhaps it would have been obvious that they were in a business role at the time and not a legal role. So you really have to think not just about the semantics of added a lawyer, right? Like plus them in, great, I'm good now, right? You have to think more about what is it that you're trying to plus that lawyer in for. Just adding them isn't going to be enough. Just adding them and then saying, hey, let's have a meeting about this where the lawyer is present might not be enough, right? Like you really have to be thinking about what kind of legal advice am I seeking? Am I asking, hey, will I have a greater legal risk if I take option 1? What are the ramifications if I take option 2, right? It might be that they don't have that much to offer, but them at least offering you their thoughts will now be the legal counsel and the legal advice that you get, which will allow you to have privilege over that conversation.
So we'll do some role playing here. Your SOC calls, they believe they've identified a critical incident. Right, the questions are, who do you contact first, and when do you, if you do, involve inside or outside counsel?
Thoughts?
Yeah, this is the audience participation part nobody warned you about for this session.
10 points.
Well, I've been through this 100 times, but yeah, basically, ultimately, CISO will declare whether or not it's an incident that is, or a breach, which is his own special terminology, but it has to be validated first, and then if it reaches that threshold level that determines it to be significant enough to be declared as an incident, then that's when the formal IR process kicks off. That's when legal gets involved as well. So they're notified. All the involved parties are essentially kind of put on the gag order, so to speak, and the process is driven essentially from legal at that point with the assistance of the CISO.
So you clearly have a very good incident response playbook and have been well trained on it. That was impressive. No, I think that is absolutely how it works in reality. I think the point here, and it's a bit subjective, is that depending on how those initial communications are handled before you determine that it rises to the level of an incident being declared, are also discoverable, right? Should the incident turn into something more. So realize it's absurd to say, right, every time something is triggered in your in your SOC, or you get a security alert, that you're going to call your lawyer. That simply doesn't make sense. But what we're going to try to do throughout this presentation is at least get folks thinking about, okay, if this turns into something bigger, right? Making sure you're thinking about who you're telling, what you're putting in writing, in those preliminary investigation stages before the lawyer's been contacted. And my tip is always, if it looks like there could be bad guys involved, that's enough, and call your lawyer, right? Like if it looked like, again, like someone misconfigured a tool, but there's no sort of intrusion or exfiltration, maybe do a little bit more digging. But depending on your company's risk appetite and your relationships, I think it's really important to have those clear points in the process where you know you need to call your lawyer and have them start putting in place processes that could give you privilege arguments down the road.
And this gentleman used an interesting word when he gave his answer, right? He said breach, which can be a legally significant term. So if something kicks off, you say, hey, we have a breach before you contact your attorneys, something that might be discoverable. Anyone looking at that is going to think themselves, oh, well, it was right here where you knew, right? The clock has started ticking, and that plays into sort of like some of the notification rules, right? In certain instances where the term breach is used very specifically is when it refers to the unauthorized access or acquisition of personal information. That triggers notification laws of some type in every state, at least to the individuals involved, meaning the person whose information it is, or in maybe about half the states to a regulator, at least one regulator. So that's a term you want to be, right? Those are the kind of things you want to be thoughtful of when you're creating this record. How are we describing this at the outset? And is it going to be covered by privilege when we do so? Go ahead.
How much does it matter who's saying things in these emails? Like, obviously, if the CISO saying something carries a lot of weight. If it's some rando SOC analyst one who's only working for 2 months, I'm guessing it carries less weight. But in your experience, I mean,
Oh, thanks. If it's all equally discoverable, does it make a difference who's saying it? Or, I mean, and how do you judge that?
I'll let Ming, you probably have a good answer to that.
I would say it's not a good fact, whoever says it, as long as it's discoverable, right? A lot of the headlines are from people who probably didn't have all of the information to be able to draw that legal conclusion, right? So it's unfortunate. That's part of, I don't know if you actually want to go to the next slide, like that's part of where you should be thinking about like, who is it that needs to be involved in the knowledge of this? Oftentimes you don't actually want that SOC guy who's been in the role for only 2 weeks as someone who's aware of this in the first place so that he could be opining on things that would later be discoverable, right? And you want to keep your IR breach team, notification team to a pretty small one where it's maybe like your legal lead, your product lead, and then your, someone from the CISO, that sort of group. Beyond that, I will say, like, to go back to your comment about determining whether or not there's been a breach, that unauthorized access, right? You have to think through, like, do I have a notification when there's confirmed unauthorized access, when I have suspected unauthorized access, when I have access theoretically, right? Like, the passwords were somehow made public available, but I don't have any indication that anything was accessed, right? So is that counting as access? These are all sort of, they're not even fact-specific questions. They're more like legal determinations, right? Based on like the context and the parties involved and all these other things. So you can certainly later argue that even if someone in a thread said something, oh, we were breached, or like, oh, we had an incident, right? You can certainly argue that they spoke ambiguously, and so on and so forth. If it becomes a large enough case, now obviously most of these cases don't actually get to the day in court, right? But if it really did, it'll still be a very bad fact and it'll still be a very bad email that makes it into the news, even if from the judge's or the jury's perspective or whomever it is, right? Even if from the legal perspective, it didn't hold weight because they didn't actually have a position of authority, the headline's still horrible, right? Yeah. So you have the PR along with the legal.
Go to our second scenario here. You decide that you want to bring in an outside incident response team. When should you sign a contract with that team, right, with that outside firm? And who should be involved? Which parties should be involved in this process?
Anyone?
In Heim. Very good. We should have brought prizes for people who answer questions.
Yeah, well, the
Do
prizes
that
are
next
outside.
year.
Yeah.
Yes.
Yep. So we generally recommend establishing these three-way or co-bell agreements well in advance. I happen to work a lot with Mandiant, so we have all that documentation is in place already. So when it comes time to bring Mandiant in on an incident with one of our clients, all we have to do is add them to the SOW, and we can get it going. We don't have to. The negotiations have been done. Everything's in place. Because obviously, as you all know, right, time is of the essence. We generally we create a new SOW for each incident, and we scope it, right, so that everything is limited and sort of packaged up. So great,
Yeah.
great answer.
Just to clarify on that one, though, when Chris is saying have everything in place, we basically mean sort of a master agreement, right? The legal T's and C's, limits of liability, that kind of stuff. You do not want to operate when you're responding to an incident under a contract, like a statement of work that was signed prior to the incident, because that it will automatically or very likely under current case law be deemed that nothing in that relationship is privileged since they were already engaged, right? So you have your master agreement, you have your rates negotiated or your team, those types of things in the contract, but then the specific SOW for the incident, right, will only be for that incident, and you'll have it from outside counsel, hopefully saying we're bringing you in to investigate for the purpose of us giving legal advice, right? And it's gonna be very specific to that scope. There's several notable cases where companies use their sort of existing on retainer IR firms to come and investigate incidents. And the courts ruled that none of that was privileged or was work product because they had already been engaged in sort of the day-to-day business.
Yeah.
Someone has an existing retainer, can they now rewrite it to be? Hi. If someone has an existing retainer, can they go back and have it rewritten to be a three-party retainer? Will that count as not being sort of already engaged with that firm or having an existing relationship?
Yeah, I think as long as the structure's right, that it's essentially a tri-party master agreement.
Yeah.
And then, yeah, at the time of the incident, your counsel directs the creation of the statement of work. I think so.
I'm saying if you already had a direct retainer in place, and then you update it tomorrow, now we've got a tri-party. Breach happens, would someone come back to it and say, oh, actually you had an existing relationship previously via this old MSA?
I think the relationship is okay. You still want to sign a new, whether it's contract addendum or statement of work, right after the incident occurs.
Yeah, I mean, it would definitely, right, kind of cut against your claim of privilege down the line. I think it was the major case on this is the Capital One, right? Capital One case where basically the judge said, well, you didn't bring in this firm for the purpose of getting legal advice, right? Well, those are the magic words, right? We, the lawyers, are hiring you, the incident response team, at our direction, right? You're working for us to provide us with something we need to provide our client with legal advice. The Capital One case, the judge said, well, look, you brought these guys in to fix a problem that you would have done anyway, right? You weren't doing it for the purpose of getting legal advice. You're doing it for the purpose of solving the problem. So that, in that scenario you posited, it would certainly cut against that a little bit if someone were to say later, well, you already had this. Because you could say, right, that's why you were doing it. But we have for sure kind of gone back and tried to unwind the clock and renegotiate those.
I would note, though, that I think your question is in particular relevant for larger companies like Mandiant, who might have retainers for other types of services, right? Like it's very likely that you would have a master agreement with Google that would cover your threat intel, products, your like managed security products, right? And all sorts of things. They just happen to be under a large master agreement, right? I think there would be a better argument there that even in that case, if you were to then enter into a new third-party agreement because of an incident, that would be defensible and distinguishable from Capital One because it would involve different teams, different products, right? It's a very clear, like it just so happens that they're owned by Google Cloud, but it's like entirely different. Yeah.
Structured in a way to where it's legal services or a subsidiary of the master company. So even though you're still contracting with the parent company, whenever it comes to the IR engagement, there's a more clear delineation in that aspect. Is that maybe a...
Or is the company that experienced the incident have legal in a subsidiary or the incident response?
The IR response team as a subsidiary of the parent company providing security services. So if you, by the day, they're your MSP or your MSSP, but during an IR incident, you engage their specialized subsidiary for those ad hoc services.
Well, that kind of brings us actually to our next slide. When you're communicating, when you're handling an incident that is involving another provider, right? Especially in MSP, we've come across some very sort of hairy situations where, right, the MSP is, there's an incident at a company, they have an MSP that handles most of their IT stuff. And as we're sort of going through this, right, maybe we hire an IR provider as well, but the MSP is helping us resolve the incident. There have been times where it becomes clear that the MSP was sort of at fault. And now we're in a situation where our legal privilege, right, goes to the client, right, which is the affected party here. It doesn't cover the MSP. If they became a counterparty, now we have a real problem because, as we're going through this and we find out, okay, well, the MSP was the one that caused this issue. Now there might be litigation between the MSP and our client. As attorneys, right, we're kind of in a tricky spot because we can't be advising the MSP, but we also know that our claim of privilege is going to be severely damaged if what we're doing is we're telling information to this MSP who ends up being, right, our adversary later down the line.
So I think the lesson from that is, to the extent you can, try to kind of isolate the team that's actually that's the team that is investing the incident in preparation for litigation or regulatory enforcement, right? As much as you can, separate those activities from the folks who are just figuring out the root cause and sort of plugging the holes. And that's, again, something that can be difficult to do, but the lawyers have experience, and this is not just a shameless plug for lawyers, but we do have experience in sort of navigating those. So if you look to your counsel to say, okay, who should be on which communications and what should be included in each one, to Chris's point, you're gonna need, if your whole security operation is outsourced, right, you're gonna need that provider's assistance to investigate the incident. But whether or not they were at fault, you really need to separate that. That's going to be part two after sort of the response is done and the remediation's done, and then you may have contractual claims against them. So we wouldn't want them involved really in the aspect of it that is preparing for some sort of litigation or enforcement action. So you want people investigating to investigate, and they don't need all the facts about the incident, and it's evolving, right? They just need, I need you to go do this, look for this, and then give me back the data. And that is one of the best ways to prevent these potentially damning communications that Ming was referring to earlier.
Can
you go back for 1 second? So, because I didn't realize we put it on this slide.
He has to go from there.
Oh, was there another question?
It's good. No.
Okay. Personal devices. I know this is a painful one. Like I said, I was in-house working with IT for a very long time. How many of you use personal BYOD in your companies? Okay. I know it is virtually impossible not to do it, but it really presents a nightmare for the lawyers if this becomes an incident that, again, gets attention from the press, from plaintiffs, or from a regulatory body. And I know that's how IT communicates, but you have to just, to the extent you can, and impress this upon the teams you work with. You do not want, right, plaintiffs' attorneys getting your entire text history off your phone, right? So if you just have that moment where you're like, okay, what if this becomes part of the evidence in a case as you're about to write that text, and take that moment to pause. When I was in-house, we gave annual training on privilege to the entire IT security organization because, again, this is not what you're trained to do, it's what we're trained to do. But seeing some of the texts, exchanges between, senior leaders in IT and CISOs when you're in the midst of an incident, nobody wants that disclosed, right, in the event of litigation. And although it may take, I know, like, you feel this sense of urgency and you need to get people involved and you need to get out there, but to the extent you can have an existing alternative to that, which is you just push out, like, we had standing bridges for incident response, right? And it's join bridge C at 5 o'clock, right? If that is a much better text message to have between IT than all these details going back and forth. So it's really that take that extra moment to say, should I really be putting this in text, or should I be picking up the phone or getting my team together on a bridge? Question back there, yes.
Now, is it the fact that they're using a personal device that's the problem, or the fact they're doing an end around the company chat platform and like using their own personal text messaging capability?
It's twofold, and I'll let you guys comment. I mean, one is that when you then get your legal hold request, right, that's going to cover your phone, your personal phone, and you're going to have to turn it over basically to the company. So the company has a legal obligation to preserve those messages on your phone and then eventually produce them. And that's both could be uncomfortable for people depending on what else is on their personal phone, but also it presents sort of practical challenges for the company. Like, think this was a big thing. You had like 27 different people texting each other on the incidents. I think just the time and the cost of collecting and preserving all of that information.
But what if you're using company email, company chat, and it just is a personal device with BY?
Then the company has it. I mean, then typically you would have processes in place to automate your legal hold process as well as to search those records. Plus, you wouldn't have your own personal, text and information commingled with that.
Right, and isn't it like the securities industry, like they're not allowed to communicate outside of the company chat anyway, right? So should we just be following that even though we're not?
I think the key part though is that even if it's in the company chat, you still have to give them your phone. Like presumably it's a personal phone, and you also have so for example, I'm not taking the best advice even personally. So I use my own device, but I have the work profile on it, and then I have my personal profile on it, right? So technically, from a legal risk perspective, if I were brought into a litigation, it would be the work profile that would be searched, because on my personal profile, presumably, I'm not talking about anything, right? But nonetheless, I'm still having to give them my phone in the first place. And so that is kind of disruptive, right? And even if it doesn't make it to the plaintiffs, I've now given my phone to my company, right? And I don't love the idea of having the company's lawyers confirm that things didn't make it over, because they probably have the right to search my personal side to confirm that I didn't actually use any of it for other purposes. So it's more of that can get uncomfortable for all of your individual employees who don't realize that they exposed everything that they have on their phone to their company because of this.
I've seen lines of employees having their personal phones imaged, and it's very demoralizing.
And your laptop, similarly, right? Like if you do a lot of personal things on your laptop, which presumably a lot of us do, right? If you have things saved on the desktop, in order to confirm that you only saved your work thing and only your work thing, they have to run the search across all of the things that were saved locally, right? To confirm which ones are responsive. So, yeah.
I think we can probably just skip through these.
Yeah, let's do that. I think we've
just for
covered a
sake of
lot of
time.
that.
You guys are smart enough.
quick.
Figured it out already.
Oh, this is a good point. Okay, so there's basically it's just making sure that you understand that in-house counsel, I made this point earlier, isn't always going to protect you and give you privilege. If they are, in a lot of companies, more of your strategic partners, sometimes your sales partners, right? Then a lot of what they are advising you on is not necessarily legal advice. It is now just business advice. So just be aware of that. And then when you're in such a high-risk situation that you want to be absolutely certain that something is privileged, probably having outside counsel involved as well will provide you more of that certainty. And I would also say there's something you should also keep in mind that actually if you go to the next slide, that there are a lot of countries out there that don't actually recognize attorney-client privilege, sometimes at all, and then sometimes in certain ways. So for example, in the EU, a lot of the countries there only recognize the privilege if it's by an outside counsel. It can't be inside at all, right? In-house is just across the board, not privileged. It has to be outside counsel, barred in the country that we're talking about or in the EU. And so it doesn't even count if you have a US outside counsel on your matter for your EU matter, for your EC matter. It has to be barred in the EU. And some of them, I believe in Europe, I think it's like Germany, also only covers the communications that are written. It doesn't cover oral communications, which is like the exact opposite you'd think of what people often expect of privilege, right? So this is to just keep in mind that when you choose to involve a lawyer for the purpose of protecting your privilege, you have to make sure that you have the right legal team on it. If you involve outside counsel, you should have the outside counsel make sure you tell them these are all of the subsidiaries or these are all of the places that might be involved. If the contracts have a choice of law that's because you're headquartered in Ireland or something like that, like where there is a EU angle on it such that your US cyber risk team may not actually be the best ones to go to, that's just something to keep in mind.
We kind of hit on some of these sort of concepts earlier, but keeping in mind who plays what role when there's multiple parties involved is very, very key. It's really, really kind of the burden falls to the lawyers to a certain degree. We've certainly handled incidents where there have been, affiliated parties, right, where their interests aligned, and because they might have shared data or shared technology platforms, and so both of their legal sort of liabilities were implicated, but in to different degrees. And as as attorneys, right, we sometimes, people think that we're everyone's attorney. And so they'll start reaching out to us, and you might end up in a situation where, let's say, you're on the other end of this, you are working for your company, you have an affiliate that suffers an incident, you're reaching out to us. If you tell us information related to this, it might not be privileged because, right, even though we're working with you to resolve this incident because all of our interests are aligned, we may not be your lawyer. So something to keep in mind there is, the sort of very distinct relationships that exist in when you're handling an incident that spans over several parties.
Yeah, we always say kind of interests are aligned until they aren't. And as we know, facts change and evolve throughout an investigation, so it's important to keep that in mind.
One of the sort of best practices that we usually recommend is being thoughtful about what the purpose of the investigation is, right, the incident response, and separating the root cause analysis from the remediation advice. The reason for that is because when we're talking about whether you're doing something for the purpose of providing, like the lawyers, right, with the information that they need to provide legal advice, saying, okay, this is what we're doing an investigation into what happened, right? It's easy to make the argument that this is supporting the information that the lawyers need to determine what the liabilities may be and then what your obligations are moving forward. When the IR firm is saying, okay, and this is how you should fix this, right? Those can be two different aspects of this, of sort of like two different pieces of fruit in the same tree, if you will. We generally recommend that we separate those out. And even really ideally, as Ming pointed out earlier, it's best to provide some of that remediation stuff over the phone and not write it down. The reason for that is, let's say, you call in Mandiant, right? They say, okay, here's what happened. Mandiant's remediation folks say, here's how you can harden your network. You can take these 5 steps to make it harder to break in. And then you don't do them. Well, later on down the line, if that isn't covered by privilege, and of course it's less likely to be, plaintiffs or regulators can say, okay, well, you knew there was a problem here, and you didn't address it, and we can see that in this written record.
And there are some nuances there, right? It could be that the recommendation to you is just as a general best security practice or as a more nuanced security practice, but that may or may not have any impact on whether or not that incident would still have happened, right? A lot of times there's this sort of claim that like, oh, if you had taken those 5 steps, those are so common knowledge, then you wouldn't have been breached in the first place. That's not always true, right? So to separate that out clearly, that even if you took these steps, a threat actor may have still been able to conduct this breach on you, right? So it's separating out the recommendations to you for generally improving the security of your system, et cetera, versus how did this specific threat occur? How did this specific breach occur? And was there anything you could have done to prevent that specific breach, right?
And ideally, just sort of connecting the dots, right? So counsel has retained the IR firm. When everything's done and they're compiling their final report, my recommendation is that it be sent only to counsel first for review. And when I would get these in-house, I tended to strike a lot of what's in there because it was exactly what Ming was saying, just sort of general advice, best practices, this is what's going on in the industry. And again, if you want to preserve the core of it as privilege, you just don't want those sort of extraneous details in your document. And so what you would do then is, so then you would have sort of a nice, tidy deliverable to counsel that can then be shared under privilege, which those in the business who need to see it. And then you have a more general call, right, with the IR provider to just sort of talk through the everything else. But that doesn't become part of the written record.
I say we only have 3 minutes, so maybe we'll go towards
Yeah, yeah. Well, so I mean, this is really sort of, you know, the last slide. We'll leave it up there for you guys to peruse, and then, you know, open the floor to any questions you may have.
Oh, we were going to leave you with 3 things. We're going to leave you with, I honestly have forgotten the third one. It was like, call a lawyer, get a lawyer involved, right? That's lesson 1. Lesson 2, think about, what was the, yeah.
You think of the third one, but mine was really be thoughtful what you put in writing. And just super quick anecdote. So the big anecdote, I said that wrong. The biggest incident I ever had to manage in-house, it was investigated by FINRA and the SEC. This is publicly disclosed. We had like a multi-million-dollar fine that we negotiated down. The documentation or the evidence, the communications were really a disaster. And it was a complex incident, right? So at first it looked like an email issue with a single, he was actually a contractor. It was an independent financial advisor that was associated with a broker dealer. And as we investigated, right, oh, now there's not just one rep, there are 3 reps, and it wasn't just the rep's personal device, it was actually the hosted email system that was compromised, and oh, after they did that, they were actually able to sort of bounce to another system and gain access. And so all of the communications from early on that were just wrong about the facts, right, still had to be turned over. And then really just the amount of time, and the investigation is coming like 2 to 3 years after this happened. So we're all trying to remember, you know, and the regulator's asking, well, why did the email on April 12th say this? And then your email 3 months later, again, all of this 3 years ago, say something different. And no one's going to remember, right, those facts. And you have to piece it together and explain it. So again, not every incident's going to turn into an investigation, but I think you should prepare like it will, because either way, having really concise, tidy communications are going to serve you well down the road.
I think it was don't CC everyone.
That's right.
Yeah.
Limit the audience.
Yeah, you have a chat group, and suddenly within like 2 minutes, someone has plus 2 more people, and someone else has plus 3 more people, right? Everyone's like, my manager should be aware, oh, my manager should be aware, and it's like, gets a little crazy. Yeah.
That's right, yes. And we know those sensitivities to tell your manager, but again, if everything's coordinated, right, then you can say, well, legal's managing this, right? They've decided who can be communicated with, and our managers or other people, you know, in the chain of command will be given updates as appropriate, right? But you don't take that on, you know, your team members don't take that on themselves. Yes.
As a SaaS company trying to limit liability, so, you know, we have a... Can you hang on 1 second? As a SaaS company trying to limit our liability, obviously we have our SaaS agreement in an order form, but it's getting a little hairy when companies want to buy through resellers in terms of how we pass on that limited liability and make sure we're totally covered. Do we still need to get the end company to sign our limited liability SaaS agreement, or just the reseller, and does that pass along, or is there something else we need to do?
So that's a great question, and the answer is it depends. And I do a lot of contracts for that. So if the reseller, if they're 2 sophisticated parties, the reseller agreement is clear that when they're purchasing that product, they are bound by your terms and conditions, and those are clearly accessible and available, and it's all B2B, not B2C, probably that's enough to retain your limits of liability. But it's really, you want it very clearly drafted, I think, in the reseller agreement. And I do see a lot of companies who simply require their terms to be attached or require the customers to sign them separately. But that, I think that's, again, based on your company's sort of risk profile and how sure you want to be that it's going to be enforceable.
Okay,
There
we
was
are
one
at
more
time,
question in the
but we'll
back.
do
Anyone?
one more
Okay.
question, if that's okay.
Oh, there's another one back there.
If you guys are willing to stay a few more minutes, if everybody would like to leave, we are at time. You could stay.
So in the vendor community, as a managed service provider, so this hypothetical has got me asking questions. So if we have an incident, let's assume that AI now is everywhere. AI generates a report within minutes, fires that off to the customer. Customer looks at it, escalates it, reaches out outside counsel, invokes privilege. So when does that privilege take effect? Is that initial report outside privilege? Is it covered under privilege because it took place before privilege was invoked? And what if now there is a lawsuit between the customer, who's now the claimant, and the service provider, who's the defendant? The conversation between them, now this person is invoking privilege, but this person originated the conversation. Do they lose any privilege to their own work product, their logs, the telemetry, the reports? Because they now have to use that same evidence to defend themselves in court. So how do you parse that? And if it's an AI-generated report, should we start stripping out any recommendations from AI-generated reports?
So yeah, I like that one, and I was really curious what the report would say. So I think, let me know if you guys disagree, but I think that report is definitely not going to be privileged. That's their sort of ordinary course of business operations. But also as a general matter, facts aren't privileged, right? So if it literally is like system got this alert, that or the other, it's probably not going to be privileged anyways. But I would check, how it's describing things and make sure it's pretty objective and fact-based.
I was going to say two things. One, anything involving Gen AI at this point is anyone's guess as to what might ultimately be decided in court, right? So, no ideas.
Well, no, I don't think a machine can claim
I
privilege.
but you never know,
That's
right?
a good, yeah,
So,
maybe
but
a few years down the road.
But I think the second point is all of your internal Gen AI tools that you might be using should all have a very clear disclaimer, or in your product design should be having a clear process. Like everyone should be aware that these should not be used for confidential attorney-client privileged purposes, right? Because they likely won't retain that because the machines might need to train on it for other things that won't be privileged. So for example, a lot of companies I know will have a very clear disclaimer for anyone trying to use such a system that you should not enter anything in here that would potentially be privileged.
But as well as to note that it could be inaccurate because it's Gen AI. That would be helpful too, that this was auto-generated by Gen AI. It has not been checked for accuracy or something like that.
So no right answer, don't worry about saying you don't want an answer, but if you were gonna follow getting outside counsel, do you follow the lawyer or the firm? And I say that only because I see pretty wide responses within a firm. And so sometimes if somebody leaves and goes to another firm because they started their own practice or because they are very good at what they do and get acquired by somebody else, would you follow the attorney or stick with the firm? Does that make sense?
It does.
Depends on how good the attorney is, I guess.
Well, I know. Yeah, I mean, during all my time in-house, I was very wed to the specific outside counsel I used. I think the other argument would be if the firm knows your company and your business very well, right? And you're using them all the time for for tax or IP or contracts, and then they kind of add their incident response person, then you might make a different decision. But I do think, I shouldn't say this, I think there are a lot of outside counsel, unfortunately, who put them out there as incident response lawyers that don't really have that depth of experience, right? And we have people like Chris, who actually worked for Mandiant and knows all the technical stuff and how the investigation works. So I think, yeah, interview your outside counsel, ask for references, but if you find someone you really like, who's responsive and gives you good advice, I don't see any harm really in following them if they leave.
How do you recommend people approach just general data retention policies, not just for general communications, but also historical SOC event disposition constantly? should
Get
they
rid
be
of it.
applying
No.
retention restrictions to that data over time?
I would say that, so it depends on how you're retaining it, really, right? The easiest way to prevent a big data breach from happening is to not have the information at hand where the bad guys can get into it. So I've responded to a number of incidents where, someone got into someone's email account, which is, can be fairly innocuous, but we look down through it and he's got a spreadsheet with 20,000 social security numbers in it, right? That was 8 years old. If you don't need the information, it shouldn't be in there. If they had any kind of automated data retention limits, which you can configure in basically any system, that wouldn't have been in there, and it would have saved this company hundreds of thousands of dollars. So it really comes down to where you're keeping it, how you're keeping it, right? Another issue that we always recommend for sensitive PI especially is using file level encryption, so that we have another layer of protection over it. So even if the bad guy gets in, right, let's say he compromises your email account, unless he has the key or the password to those specific files that are really sensitive, he can't just access it under the auspices of the privileges that he has already co-opted. So that's a very common piece of advice we give out.
And I think email in many companies is like the biggest risk, and it's the least well controlled. So I'm a huge fan of like some reasonable auto deletion of emails older than like 2 years or whatever is reasonable for your industry, because that can become a nightmare. But I love that you asked that question, because I'm actually giving a presentation in a couple of weeks on the convergence between data governance, privacy compliance, and AI governance. And so you spot it right, they all work together. And you really need to pay attention to each to put yourself in sort of the best security posture you can.
So do you apply data retention policies then to like just general everyday SOC, your SOC database?
Oh, absolutely.
Alert 500 times, which is key for us figuring out like, hey, I've got to actually apply control looking at those trends.
Yes. Alerts and like system logs and things like that absolutely should have retention periods.